May I please, Your Lordship? Your Lordship, I beg to mention item number 8.
8.
Yes, Your Lordship. I'm mentioning on behalf of the Senior Counsel Gauhati for the respondent number 6. Your Lordship, we are yet to file our affidavit here. So I pray for 2 weeks.
Item 8.
Yes, Your Lord.
Younger what is appearing for
Respondent 6, Your Lord.
respondent 6. Mention has been made on behalf of Mr. Younger Wati, who appears on behalf of respondent number 6.
Yes, Your Lord.
What's his problem today? Personal difficulty.
Yes, Your yes, Your Lord.
He, as Younger Wati, has some personal difficulties today. Prayer is made for
3 weeks, Your Lord.
made for listing the matter after 3 weeks. Prayer is allowed. Learned Counsel Takakichu appears for the petition. This is the matter after 3 weeks.
Obliged, Lord.
May I please, my lady? I'd like to mention admission item number 7. Here I'm here to file affidavit and reply.
7.
Yes, my lady. Kindly grant me 3 weeks' time
You are for
for the petitioner,
Learned Counsel. Your name,
Ali Bauzukum.
Pausakam, appearing for the petitioner, has prayed for
3 weeks' time.
3 weeks' time to file an affidavit in reply.
Yes, ma'am.
Learned Counsel for the respondent government, Lordship, has no objection. List the matter of the 3 weeks.
There is an interim.
In
may
the
be continued.
meantime, the petitioner shall file the affidavit and reply. The interim order issued shall continue till the next date.
Obliged.
May I please, Lordship? Lordship, I beg to mention item number 11 and 12. Lordship.
11 and 12.
Lordship, on behalf of Mr. Gray, additional AG.
Sucre.
Lordship. Lordship, can you
Yes.
list this matter after 3 weeks? I've taken the consent of the petitioner.
With the consent of the petitioner, the learned governing advocate, your name,
Pichano.
P.
Pichano.
P. Chanlo. Praise on behalf of additional AG, V. Shukre, that she's out of station on some official work, and praise for listing the matter after 3 weeks. List the matter, accordingly list the matter after 3 weeks.
Lordship, similar prayer with item number 13. On
One-
behalf of
1-3, 13.
Lordship, on behalf of Tipapom,
After this one also after 3 weeks.
Lordship.
Item 13, prayer is made on behalf of Mr. Tiba Pom, Government Advocate, for listing the matter after 3 weeks. Learned Counsel for the petition is present and has no objections. List the matter for hearing after 3 weeks.
Lordship, similar prayer with item number 14 and 15. On behalf of
14 and 15.
Moa Imchen,
More in June. 14
kindly
and 15.
list this matter after a week.
Prayer is made on behalf of Mr. Moa Imchen, Senior Government Advocate, for listing the matter after 1 week. Counsel for the petitioner is present. Prayer is allowed. List the matter after 1 week for hearing.
I oblige, Lord.
Lordship, I beg to mention, hearing item number 16, Your Lordship. I'm for the respondent. Yes, Your Lordship. This matter could be on for 3 weeks, Your Lordship.
3 weeks.
Yes, Your Lordship.
Yes. 3 weeks. Prayer is made on behalf of Mr. Gauhati, learned
Yes, sir.
CGC, that the matter may be listed after 3 weeks for hearing. Learned counsel for the petitioner has no objection. List the matter after 3 weeks for hearing.
Obliged, Your Lordship.
May I please, Your Lordship?
Yes.
Your Lordship, may I be pleased to mention, item number 5, Your Lordship.
Item 5.
Your Lordship, here, some, there's an error, Your Lordship, in the name and, in the PIM cell, Your Lordship. The petitioner's name is,
Mhm.
there's an error. And the date of birth is also an error. So the
Mhm.
petitioner has to take steps in that regard, Your Lordship, and that's why, Your Lordship, we could not able to take steps also. Your Lordship, yesterday, last night only, I intimated the petitioner. So maybe sometime may be granted to us so that we can able to take steps in this regard.
You may have to make amendments now. You may have to make amendments in your petition. If
No,
the
no,
PIM's
No, no,
number.
your, yeah, no, Your Lordship, they have to forward through a proportional, they have
Oh,
to
acha,
forward
acha,
to the
acha.
PIM cell and
Mhm.
make
Okay.
necessary correction, Your Lordship. That's why I'm
So
not
we'll
able to
just say
file
that
an affidavit.
some instruction is required. huh?
Yes, Your Lordship.
Learned counsel, the government counsel, Livika, appearing for the state respondent, has stated that some instruction is awaited with regard to the PIM's number of the petitioner. And therefore prays for,
Maybe 4 weeks, Your Lordship.
prays for 4 weeks' time. Learned counsel for the petitioner has no objection. This is the matter after 4 weeks for admission. Imagine.
Your Lordship, I also beg to mention item 6 on behalf of K. Hangami, Your Lordship.
Hmm.
She's having some personal difficulties today, so let the matter come up after 3 weeks for filing counter, Your Lordship.
Profiling counter.
Yes, Your Lordship.
Item 6. Mention is made on behalf of K. Angami, government advocate, who is yet to file the counter affidavit on behalf of the state respondents. Praise allowed. List the matter after 3 weeks.
Your Lordship, I may also be allowed to mention item 8 on behalf of AIME. Item 8,
8.
yes, Your Lordship.
8 is already mentioned.
Oh, Your Lordship.
3 weeks.
Okay, Your Lordship,
Yes.
then, Your Lordship, if it is not mentioned, item number 17, Your Lordship, hearing number item 17.
Yes.
Your Lordship, after 3 weeks, Your Lordship.
State is a
Or-
party.
Yes, state is a performer responding, Your Lordship.
Petitioner, respondent, no one is there. Item 17, hearing item 17.
Yeah, my senior is in court number 1 now. So we
The
are
government
planning
is-
to take up if times permit.
Your Lordship, I mean, from the state is a performer, so maybe if the main respondent is already there.
I'm also informed that the main respondents are also on the
Oh,
way.
then let
We're
it come.
changing our
Okay.
My please, Your Lordship.
Yes.
Your Lordship, I beg to mention item number 8, 9, Your Lordship.
Item 9.
Yes, Your Lordship, for all the respondents, if this matter could be adjourned for 3 weeks as we are yet to file our affidavit, Your Lordship.
Of India.
Yes, Your Lordship.
Item 9. Mention is made on behalf of Mr. Gauhati, learned CGC, that they are yet to file the counter affidavit.
Yes, Your Lordship.
Praise allowed. List the matter after
3 weeks,
3
Your Lordship.
weeks. In the meantime, the respondents will file their affidavit in opposition.
Obliged, Your Lordship. Obliged, my lord.
For admission, item number 1 and 2.
My Mr. Lordship, on behalf of Visible, the state is zero file, so if this matter will come up after 2 weeks, Lordship.
To file counter,
Lordship,
2 weeks.
Lordship.
Prayer is made on behalf of Mr. V. Zimomi, London State Council, praying for 2 weeks' time to file his affidavit in opposition. Stop. Prayer is allowed. List the matter after 2 weeks. Learning counsel for the petitioner is present.
For admission, item number 3.
Please, Lordship. Lordship, the newly imputed respondent, that is respondent number 9,
It's yet to
Hmm.
file affidavit in opposition.
Respondent number 9.
9 is represented by Mr. Harish Gupta, CGC from Guwahati.
Okay. Hmm. You know that, counsel for the petitioner, you are for the petitioner, no?
Yes, Lord.
Submits that the newly impleted respondent number 9 is yet to file his affidavit in opposition. The learned counsel for respondent number 9 is absent today. List the matter after 3 weeks in order to enable the respondent number 9 to file the affidavit in opposition, if so advised. Stop. Learned government counsel is present.
Obliged.
For admission, item number 4.
My lord, I have filed my affidavit on behalf of the state respondents.
Union of India.
My lord. I have not received any instruction yet, my lord. In this regard, in the petitions, there is no single word indicated against the debt respondent. This is particularly compensations for destructions of the property, my lord.
So the
the-
main respondent is the union,
No, my lord, state.
the state.
Yes.
So you will not be filing your affidavit in
No.
opposition?
Accordingly, I have not received instruction, so
No, but here the Ministry of Road Transport Highways is included.
yes, of course, we have updated this party, but performer respondent,
Then what about 6 and 7? Is 6 and 7 represented? You have filed?
Yes.
Okay,
even in respect of 7, I have filed my return.
okay. So you need time or
Yes, my lord,
we'll put it for hearing now?
Lordship will be filing a reply to the opposition filed by the state respondent.
Okay, okay. Learned additional AG, Mr. LT Sanctum, has submitted that he has filed the affidavit in opposition on behalf of respondent number 3, 4, and 5. Stop. Learned counsel for respondent number 6 is present. Learned counsel for respondent number 7 is also present. Affidavit in opposition on behalf of respondent number 6 and 7 has also been filed. The Mr. Z.N. Muli, learned CGC, appears for
respondent
respondent number
two.
1 and 2. Oh, respondent number 2.
yes.
Acha, that LT Sanctum na is respondent number 1, 3, 4, and 5. Okay. And Mr. Z.N. Muli is for respondent number 2. Who submits that the state government is the main respondent in the
And
present
as well as the
case.
contractor, my lord.
And he is yet to receive instruction. Learned counsel for the petitioner also submits that they would like to file an affidavit in reply to the counter affidavit of the state respondents and prays for some time. Prayer is allowed. List the matter after
2 weeks.
2 weeks,
3 weeks, my lord. 3 weeks.
after 3 weeks for admission.
Bless
Last
my
day,
lord.
lord.
For hearing, item number 10.
It's appearing for
Livika and
state respondents.
Dimawapal. My lord, I think they are having a matter in the hosting DB.
Could be.
Yeah.
Livika. She's busy. If you pass it over, we'll pass it over okay,
My lord, if
for the day. If they're on legs in the other court, then they wouldn't be able to come. Divika, item 10, hearing. You
Lordship,
ready?
I was in court.
Yeah, it's okay. But respondent 5 is also there.
Your
No?
Lordship, he has his feet in the upper court also.
Oh,
So that is the-
My lord, in this case, we
Yes.
can take a matter of half an hour.
okay, let's wait then. No?
Yeah.
But the other case also, item 17 also, I think all the councils are engaged
could be,
in
yeah.
the other court. Mm.
So we take up the matter of.
Just inquire whether he's free or not at the moment. I mean,
Okay.
This only. a short matter.
Otherwise, we can rise and then sit after half an hour.
Yeah, no problem, also.
Because item 17 also, I think no one is there. No? It's quarter to. So 12:15.
Right.
Yes.
Yeah. My lord. This is a matter pertaining to a grade 4 pause.
Mm.
My lord, coming to my district. My plate.
Mm.
Page 22, issue order.
Page 22.
Yes,
Yes.
this is an appointment order
Mm.
given to the respondent number 4.
Mm.
This order dated 13 December 2018.
Okay.
Yeah,
Annexure 2.
annexure D,
Oh, D.
page
Annexure
22.
D, page 22.
Yes. Now, my lord, coming to the
Yes.
annexure A, this page 9. Translated copy is on page 10.
Mm.
May I read the stick,
Sure.
page 10, this translated
What,
copy.
this is what agreement?
This is the agreement between the landowner and the government.
This is dated
This is dated
13/1/88.
1/2/88. Yeah,
No, no,
13/1/88.
13/1/88.
Yes,
Mm.
13. I read out.
Yes.
Proposu civil hospital land boundary demarcation and agreement thereof. The following officials and public leaders, including the owner, resurvey the land boundary demarcation as per original agreement while donating land free of cost in lieu of grade 4 pause for construction of hospital on dated 13 January 88. There are only 4 land owners, namely 1, 2, 3, 4. Now, my lord, I am the son of this landowner number 4. I further read. The first 3 landowners are already given grade 4 pause, and the last one, Mr. Dolye, brother of Fazilia's son. Fazilia's son of Sezole Sire is yet to be given 1 grade 4 pause. So, till date, I have not evaded this grade 4 pause. Being
No one from your family.
no one from my family. So, my lord, coming to page 12, that is annexure B. One of the landowner has made an affidavit
Mm.
to the effect that Dolye has never availed any grade 4 pause, Dolye nor his sons. So this is an affidavit made by one of the landowners.
Where is that? Page 12.
Page 12, annexure B, para 4.
This is regarding name, that my official name is such and such, that in my academic records, my name is such and such. So just
No.
meaning that the 2 names are the same person.
Yeah. Henceforth, my name shall be known as sorry, yes. Then,
So this has got nothing to do with
yeah.
the land ownership.
Then my lord, in annexure C1, this is page 21.
Hmm.
See, yes. Here, this Niveau Zolier, he is one of the land donors. His name is reflected in the agreement. His name is reflected in the agreement serial number 2, Zorhelie. So Nivo Zoli is the son of Zorhelie, and he is one of the landowners. So I read out para 3. That as per mentioned agreement from serial number 1, Sri Vizokolie and from serial number 3, Vizokolie were appointed in the year 2023, and from serial number 2, my wife, namely so-and-so, was appointed in the year so-and-so, 2008 in the department. That as per agreement serial number 4 has not availed any post till date. That this affidavit is made to declare that Medonitio, who is the petitioner here, son of Dolie, serial number 4, as per agreement, is the rightful candidate to appoint in the vacant post created by so-and-so as medical attendant in the office of the CHC Chepobuzu on retirement on dated 30/9/2018. So this is the facts of the case.
You're saying that the private respondent was appointed without any selection process. Is that your ground?
She is not one of the land owner. She has no right to be appointed. Because as per the agreement, grade 4 post should be given to the landowners who have donated the land. Now, one of the landowner also has stated that I have not availed any chance in the grade 4 post. Now, my lord, coming to the affidavit in opposition of the respondent 1 to 4. They have stated in Annex C, that's page 10. Page 10.
Affidavit of state respondents.
Yes, state respondent.
Mm.
1 to 4. Page 10.
Wait. Yes.
As per these, they have stated that I have already received an amount of rupees 3,800. And they have appended this
Page
in
10, Annex
page
C.
10, yes, Annex C.
Mm.
They have stated that I have received an amount of rupees 3,800. And in the next page,
Have already received land compensation as
Ye-
per record.
yes,
Mm.
they are stating that I have received 3,800.
Mm.
And as per the list
Mm.
in serial number, in the next page,
Yes,
in serial number 48,
48.
yes. In serial number 48, the amount here is 3,500. There's no signature appended to it that I have received this particular sum of money. Next page,
11,500.
page 11. In Annex C, they are stating that I have received 3,800.
Mm. Annex C, rupees 3,800.
Yes, and in the subsequent page, that is page 11, my name is been marked, but here the amount is rupees 3,500. And on top of that, there is no signature appended to it that I have received it. There's no documentary proof to show that I have received sum of money. Now, my lord, coming to
That
page,
matter, nobody's signature is there. None
course.
this. Mm.
yes. Now, my lord, coming to page 12, Annex D. Para 3A, it's clear.
para 3A.
A, yes. I read out the para.
Mm.
In other case, prior to 26/7, 2005, and subsequent to setting up of administrative and block headquarters on freely donated land, where specific written agreement exists, providing for employment to the landowner. The claim of the landowner for employment should be settled in terms of such agreement. So in the agreement, it's ample clear that I have not been given
Mm.
Yeah, now my lord, coming to the additional affidavit of the state respondent.
Yes.
Yeah. Page 5. Page 5. This is an order passed by Justice Kisema.
Mm.
Yeah, I read out. In the course of hearing, Mr. So-and-so, learned counsel for the petitioner, has submitted that Mr. Dolie Angami, one of the landowner who has donated the land for the construction of Chepobozo Civil Hospital, is not the brother of Fazilia. Whereas Mr. So-and-so counsel for the respondent number 5, referring to the order dated so-and-so, to the affidavit in opposition filed by the respondent 5, submit that Dolie Angami and Sri Fazilia are brothers, and as Fazilia has been appointed as medical attendant at so-and-so by the order dated so-and-so, the appointment of the landowner which is claimed by the petitioner in the present petition cannot be sustained. In view of the contrary stand adopted by the learned counsel for the petitioner as well as the learned counsel for the respondent number 5, Mr. So-and-so, learned counsel for the the government advocate shall place the necessary instruction from the government department as to whether Sri so-and-so and Sri so-and-so are brothers, relative of the same descendant who have donated the land for construction of the Chepobozo Civil Hospital. The instruction shall be placed in the form of affidavit. Now, my lord, coming to page 7, annex to C. Page 7, annex to C.
Mm.
Yeah. I read out.
Yes.
Madam, as directed through your letter number so and so, I have the honor to submit that the under mentioned clarification in regard to
WPC suggests-
WPC so and so versus state. Number 1, that the land for the establishment of community health center Chepobozo were donated by 4 clan: Jadi clan, Kizio clan, Rohok clan, Sere clan. That Dole is the son of Kuno. However, Fazile is the son of Sezole. That is, they are of different father. Thus, it may be concluded that they are not blood brothers of the same father, rather distant brother of the same clan. So that is the order of the chief medical officer. Annexure, page 8. Page 8 indicates grade 4 appointment
Mm.
in the same office. Now, Jadi landowner in the original agreement, there are only 4 landowners.
Yes.
So Chati landowner, Kizio landowner, rural landowner, and Syria landowner. Syria landowner, so one facility has got, but he's not the landowner in the original agreement.
Mm.
So my prayer is the court should set aside the order, the impugned order, and pray that the honorable court was necessary order in favor of the petition. That's all.
So who is respondent number 5? Is respondent number 5 also a landowner?
No.
Mm.
No. As per the Annex 3A, page 9, there are only 4 landowners. Yes. And these in the agreement signed by in presence of the civil surgeon and in witness of the civil
Yes.
surgeon along with the landowners, the public leaders. So this is the agreement. Yes.
See, Devika, the agreement is there, 4 landowners were there. I agree that now the situation is different, but the notification of the state government itself says 2005, before 2005, whatever was decided, whatever was agreed in the agreement, that will follow, no, regarding the appointment and all that. So, and of course, now the situation is that only one person can be appointed and it cannot continue in perpetuity.
Yes.
So, the other 3 clans, they have already been appointed, and he says that his ground is that only his family has not been accommodated. And you have also not denied.
Your Lordship, I have already stated, the state of the government is that, Your Lordship, we have not only compensated the land, but also like as per the agreement, the clan of the petitioner has already availed the appointment. And therefore, since there is already a policy of the government that the appointment cannot be made in perpetuity, therefore the petitioner is barred to come before this court to seek appointment on the basis of that agreement, because the government has already honored that agreement by giving appointment to one a person, Your Lordship, and that is he is the brother. He's the same. He belongs to the same clan of the petitioner. And therefore, Your Lordship, by virtue of that, the petitioner cannot come knocking before this court or seeking appointment on the grant for appointment. Now, Your Lordship, to substantiate.
Wait, there are 4, no? So
Yes,
one
Your Lordship.
Rolho, Peziye, Chadi, and Sive. So you're saying that petitioner is from which clan?
Your Lordship, the petitioner serial number 4, Dulo.
Oh,
Petitioner number 4, he belongs to the clan of Sire, Your Lordship. And I will come to all my documents, Your Lordship. The facts of the case, I will bring it before Your Lordship. And basing on the document, Your Lordship, like I will satisfy this on Your Lordship that the appointment has already been given, and therefore, Your Lordship, the petitioner is barred from seeking grant for appointment basing on the agreement, basing on this agreement, Your Lordship. But let me come to my affidavit in the position, Your Lordship. And
your affidavit in the
my
position.
affidavit in the position. My annexure A, page 7, Your Lordship. This is the agreement, so I will not read it out, Your Lordship, because the petitioner has already relied on this, and it's very clear that there was 4 landowners who has donated the land, and the 4 landowners are as stated by the petitioner. It's Charu, Rulo, Turolile, Bezie, and the third I cannot actually pronounce it like Chade. The title is Chade, and the fourth one is the petitioner, Your Lordship.
Siri.
Dulo, son of Kuno Siri, Your Lordship. So now, basing on this agreement, if we can, if you allow me to read the
Yes.
following portion. The first three landowners are already given grade 4 post, and the last
You're
one,
reading from page 7, huh?
yeah, page 7, Your Lordship. Your Lordship, you got it?
Yes, yes.
The first three landowners are already given grade 4 post, and the last one, Mr. Dole Angami, brother of Fuzile, son of Sezule Siri, is yet to be given one grade 4 post. All agreement were finally settled as per the original agreement, and further land dispute will arise provided one or no further land dispute will arise provided one grade 4 post given to one brother of Mr. Dole Angami of Nirma village. Your Lordship. So this is the agreement here. Now, Your Lordship, if you can kindly come to the petition, the writ petition. The writ petition, Your Lordship, I want to refer to the writ petition, page 23. There's an order of this court. The petitioner, page 23, annexure A, Your Lordship. And I believe Your Lordship was also one of, we stand for the government, Your Lordship. When you were, Your Lordship, in this case, 164K of 2001, page 23.
Yes.
This is the judgment passed by Justice L. Lamre.
Mm.
Lordship, here the petition, they came before this court, say that like they were not being given landownership, like compensation, as well as equal opportunity of agreement was not given, Your Lordship. And therefore, what did the court pass, Your Lordship? If you can come to the operative portion, page 7, Your Lordship. Paragraph 7, page
The
26.
same land.
Your Lordship, same land, Your Lordship. They have come before this before the court, seeking stating about the land compensation as well as not giving equal opportunity of grade for appointment. Your Lordship, the court did not dive into the compensation because that was not the question before the court. The question was giving equal opportunity of grade for appointment. Now, what was the observation given by the court? Your Lordship, if you can kindly come to page 26, operative portion of page 26. Operative portion is at page 26.
Yes.
Page 7, paragraph 1. Oh, I will just see the clause 1, 2, and 3 only, Your Lordship. May I read, Your Lordship? Page 26. Read petition, page 26. Clause 1, Your Lordship. Your Lordship, I read.
Yes.
That if there is any vacancies in the state civil hospital, the case of the petitioner shall also be considered along with the all other landowners for appointment to grade 4 post in the hospital. Clause 2, the henceforth equal appointment should be given to the grade 4 landowners to 4 landowners to the grade 4 post, and that no other landowner shall be discriminated by giving less appointment from the family of the landowners. Third, the reform shall also consider for allotment of small contract works to the landowner as per the agreement. Now, this was the direction given by the Honorable Court. Your Lordship, this case was filed by Mr. Vignozio. And I believe in this case, the present petitioner was the respondent. The respondent in the case, Your Lordship. So now the observation of the case of the Honorable Court was that equal opportunity should be given, the grade 4 should be given to the landowners, to the 4 landowners, Your Lordship. Now, by virtue of this judgment passed by judgment on order passed by the Honorable Court, if you can kindly come to my affidavit in opposition now, Your Lordship. Page 9.
Wait, just go slow. 64, 2001. So in this 164,
Yes,
petitioner's name.
petitioner is
not
a
there,
respondent
but
here.
Respondent number 7.
Yes, petitioner was the respondent. Your
Petitioner's
Lordship.
father, I think.
Yeah, petitioner's father.
Mm.
Yes, Your Lordship. Petitioner's father was the respondent in this case, Your Lordship.
7, respondent 7.
Yes, Your Lordship. And one Vinizio filed this case. Now, by this case, Your Lordship, by this case, there was a direction that all the respondent as well as the petitioner, because I believe the petitioner was also the landowner. So they were, the direction was that equal opportunity should be given as per the direction of this Honorable Court. Now,
Then your,
My affidavit in opposition page, if you can kindly come to my page 9 of the of my affidavit, page 9, Your Lordship. And it should be. Now, may I read, Your Lordship? Now, this will be very clear, Your Lordship. May I read, Your Lordship? As the court's verdict of Gauhati High Court Kohima bench number WPC number 64K of 2001 passed to us on 18th June 2003. We, the landowners of Civil Hospital Chepabozu, hereby adhering to the same verdict, solemnly agree the following resolution. Now, Your Lordship, 1, at times, the government department may not accommodate equal job facilities to all the landowners in one go. Therefore, the jobs grade 4 posts are to be filled by landowners on rotation, I think it's rotary turn basis as per this, by the landowners as mentioned in the court verdict, Your Lordship. 2, no contract work shall be allotted to any outsiders within the perimeter of the Chepabozu Civil Hospital other than the landowners. Now 3, when any of the landowners are employed in the same hospital utilizing his quotas, the other landowners who has not been employed in this above said hospital shall have reserved for the contract work which arises from time to time. Your Lordship got it? Now, Your Lordship, nota bene. Your Lordship, that will be very important. Nota bene. Since all the aforesaid landowners have now employed in the said hospital, except, Your Lordship, except Mr. Nivotsile next king shall have reserved for the next vacancy of grade 4 post whenever arises. He shall also have the right to reserve all the contract work till he utilize the job reservation. Now come to the signature portion, Your Lordship. Yours faithfully, Dole, son of Kuno. Now he is the father. The first signatory is the petitioner's father, Your Lordship. He himself has agreed, he has appended his signature, he has made an agreement that we have received. Except now one Mr. Nivozule, the next king. That is also not the person himself, but the next king. This person only, except this person, all the other landowner has already received grade 4 appointment. And this is an admittance of the father, of the petitioner's father. It's very clear, Your Lordship. Yours faithfully, if you can come to the document, Your Lordship. The first signatory is Dule. There is a 3 signatory. There's a 4 landowners, Your Lordship. And now the 3 has already given their signature here. The first signatory is Dule, son of Kuno, Your Lordship. Second is Dulese, and third is Nivotsile, Your Lordship. Now, Your Lordship, Dulo is the father of the petitioner, Your Lordship. He has already agreed that appointment has already, I've already availed the appointment, except this person, Nivotsile, next king, has not availed. Now, the petitioner's father himself has admitted that the appointment has already been given. Now, Your Lordship, as per the agreement, as per the policy of the government, as well ever by this honorable court, there's a policy brought out by the government in 2018, where in paragraph 3C, it has stated that employment cannot be provided in perpetuity, Your Lordship. Now, when we have already given an appointment, now we have all, Your Lordship, we have already, appointment has already been availed to the petitioner's clan, and Your Lordship, on the honorable court on 15/10/2014 has given a direction to furnish before the honorable court about the family relation between the petitioner and the person who we have appointed. And therefore, we have taken steps. We actually wrote to the chief medical officer. The government wrote a letter to the chief medical officer. And accordingly, we had got a clarification that the petitioner and the person whom we have appointed, they belong to the same clan, Your Lordship. Your Lordship, if you can come to the operative portion, page annexure 3 of my additional affidavit, Your Lordship. Page 7, Your Lordship. Annexure 3, page 7 of my additional affidavit. Additional affidavit.
The letter written to Principal Director.
Yes, now the Chief Medical Officer, in my annexure 2, a letter was written to the Chief Medical Officer to ascertain the family relationship between the petitioner and the person whom we have appointed. And accordingly, the Chief Medical Officer wrote back to the Principal Director stating that, I think para 2 will be relevant, that Mr. Dolo is the son of Mr. Kuno Sire. However, Mr. Fuzile, if I'm pronouncing correctly, is the son of Mr. Sezule Sere. That is, both are of different father. Thus, it may be concluded they are not blood brothers of the same father, but rather of distant brother of same clan, Siri clan, Your Lordship. Now, if we can come to my next page, there is a category, the government has already stated categorically. Chade land owners, Kezo land owners, Rulo land owner, and now Siri land owner. Now, all this column, they have already availed the appointment, Your Lordship. Now, Siri clan also have availed appointment by one Mr. Fuzile, Your Lordship.
But it says retired.
Now, Your Lordship, whether it's retired or not, that is immaterial. The question here is whether we have
Only
given
one-
appointment or
one
not.
can be given.
And now the policy brought up by the government is that only one
one.
appointment should be availed to the family, and it cannot be done in perpetuity, Your Lordship. So, Your Lordship, by virtue of this, the petitioner does not have any right to come before this court seeking appointment of grade 4 post on the basis of land ownership, because we have already given, Your Lordship, we have honored the agreement. We have not only compensated them, but we have also actually honored the agreement by giving grade 4 appointment to them. And therefore, availing both compensation as well as grade 4 post, the petitioner now cannot come before this court seeking that they have not been actually given the appointment, Your Lordship. The petitioner knows the fact they are actually coming before this court with unclean hands, Your Lordship. Your Lordship, now petitioner is stating that he will be covered by this 2018 clause A. In other cases, prior to 2005, subsequent setting of so and so, headquarters on freely donated land where a specific written exists, Your Lordship. But Your Lordship, we have already honored, Your Lordship. If we have already honored the agreement, and therefore, Your Lordship, when we have honored the agreement, the petitioner now cannot come before this court seeking that he should be appointed on the basis of land ownership, Your Lordship. And now the petitioner has also made one submission. I want to make it clear, Your Lordship, that we have not received the money. But that is not the question before this court. If he can kindly come to the prayer of the petitioner in the writ petition, that is not the subject. He has not averred about compensation in this case. So, Your Lordship, even if the petitioner make a submission about compensation that he has not received, that is not a subject matter here. He has not averred anything about compensation in this case, and therefore the petitioner cannot be allowed to go beyond his pleading. Your Lordship, and the law is very clear. Whichever is beyond the pleadings, Your Lordship, that cannot be considered. Your Lordship, so the petitioner has made a statement that he has not received. That's why, Your Lordship. If he can come to the prayer portion, Your Lordship. The petitioner has not made any whisper about compensation. The question of compensation was never an issue. The question is, he should be appointed on the basis of land ownership. That's it. And the government, on the other hand, has already given them the benefit, and therefore, by virtue of this, he is not entitled. Has no locus standi also. Your Lordship. So, Your Lordship, with that, I leave to your jurisdiction.
Yes.
Yes, in this case, I'm for respondent number 5. If I will file my affidavit of opposition.
Yes.
After my affidavit of opposition.
Yes.
Finally come to page number 6. This is an order issued on 2nd June 2014. This is my initial appointment for a period of 1 year. This order was issued in the year 2014. The petitioner's name figures at serial number 1.
Page 6.
Evil Hosano.
Okay, serial number 1.
Yes, Worship. Lordship, initially petitioner he was appointed as a medical attendant in the year 2014.
Mm.
And this appointment order was extended from time to time. And Lordship, may come to page number 15.
15.
This is an order dated 28 July 2018,
Annexure 3.
Annexure 3.
15.
One Vizuli.
Mm.
He was released from service with effect from 30/9/2018.
Mm.
Against this retirement vacancy, the petitioner, the respondent number 5, he has submitted an application
Mm.
bring for consideration of her case.
Mm.
Lordship, the state respondent by a letter dated page number 17. Page number 17. 25/10/2018 has forwarded the list of 9 applicants claiming for appointment against this case.
Applications.
9 applicants.
Mm. Your name is also there.
My name also Lordship. My name is serial number 1. Page number 18. Lordship, the state government has considered my case and by order and by next page.
Has been serving in Japan since June 2014. Mm.
Lordship, page number 20.
20.
Yeah, 20. Lordship.
20.
Annexure 6.
Mm.
Lordship, by this order, the petitioners was temporarily appointed against a resultant vacancy. And now this order is under challenge. My initial appointment order is not under challenge in the present petition.
Mm.
The
Initial
order wa-
appointment is May,
May the-
2nd May 2014.
2nd May 2014. The order which is under challenge, this is a order of 2018. This is a continuation of 2014 order. Bishop. And my initial appointment is not under challenge in the present petition.
Mm.
Bishop, there's also one issue. Bishop, but the main issue is in the present petition is
Mm.
the maintainability of the present petition. Here's the twisted facts stated in the present petition.
Mm.
So the present petition is not maintainable at all. The present petition has been filed under Article 2 to 6.
Original appointment not challenged. No?
Original appointment order not under challenge. That is also one issue. But the main issue is, my condition is, the present petition is filed with a twisted facts.
Mm.
But by suppressing the material facts. So the present petition is not maintainable.
By suppressing the appointment of his clan member.
Lordship, may come to para
Mm.
para 89 of the petition. Here they have categorically stated that your family has not availed any appointment. Lordship, this is a false statement. Para 18 of the petition.
Where it the 9.
89.
Petitioner states that
But the petitioner states that so far not even a single member from his family have been appointed to the resultant grade 4 post arising in the said community health center. Whereas other landowners have been availing second chance of appointment by virtue of being the landowners of the said community health center, and thus denying equal opportunity even amongst the landowners. Para 9, that the family members of the other three landowners have availed. Here the other 3 landowners have availed more than one appointment on consideration of being a landowner. However, the petitioner's family being cultivators are not in position to know the vacancies, hence missed to avail his employment. Thus, second chance had been availed by some other landowners, whereas in the present petitioner's case, none of the family member has been accommodated in the grade 4 post. The last sentence is very important. None of the family members. Lordship, my learned state counsel, he has highlighted the whole facts. And as per the facts which he has narrated, one Fusili, the in the petitioner, the Dolly, the petitioner's father, they're from the same clan. And this supposedly from the same clan, he has already availed of one lordship. And lordship, if we come to the,
Even in that chart, it is there.
in the chart is there,
Jati, then Kezio, Rulho, Siri.
just, and lordship. Lordship, that crown, lordship, I've taken in my affidavit of opposition, lordship may come to page number 23. In my affidavit of opposition. This is the appointment order of Fuzili, Siri,
Page
page
23.
23. This is the appointment order of Fuzili,
Annexure 8. no?
lordship.
Fuzili.
Lordship, in the last hearing, when this matter was heard on 15/10/2024, I raised this issue before this honorable court. And this honorable court was pleased to pass this order 15/10/2024, which the state government has annexed their additional affidavit
To
And
verify.
to
Regarding the
directing
criteria.
the state respond to make to conduct a verification.
Mm.
And as per the verification report,
Mm.
it clearly states that Toli and Fozili, though they are not the real brothers, but they are of the same clan. In this part, they have not denied, they have not denied this part. They have admitted. The facts which is not controversial is simply admitted. Lordship. And Lordship, we come to the affidavit, in the writ petition. Well, Lordship, this is regarding the earlier litigation, which has come before this number, page number 23.
That WPC 154.
WPC 164, Lordship. Lordship, admittedly, the lien was donated by the four clans. In the agreement, Lordship, in the agreement is page number 9. This writ petition was filed by the Charu Rohul clan. Page 9.
Mm.
In the doc,
Charu Rohil.
there are only 4 landowners, namely, one is Charu Rolho, Torsili, Rovisi, and Toli. In the present, this WPC 164 was filed by the serial number 1, Charu Rolho. In this writ petition, the petitioner's father, Mr. Dolly, he was employed as respondent number 7. What was their admission before this honorable court in the earlier writ petition? We should come to page number para 6. Here they have made a specific statement, admission before this honorable court. Before I read this para 6, kindly note the appointment order issued in respect of Mr. Fozili.
Mm.
That was issued in the year 19.
Just give me the date of this Fuzili's appointment, page 23, annexure 8.
6 February 1989.
6 to
1989.
89.
That's for sure. After appointment of
And
Mr.
this
Fozili,
petition is
19, this writ petition
2001.
2001. So after the appointment of Mr. Fozili, this writ petition came up.
Mm.
So what they have admitted before this honorable court in the paragraph 6.
Mm.
Should may I read the paragraph 6?
Yes.
Paragraph 6. The seat respondents in paragraph 15 of the affidavit of opposition has categorically stated that all the landowners of the civil hospital have been treated equally. An equal opportunity for appointment have been given as per the agreement without any discrimination. That was the statement of the state respondent, where your lordship has said. And the next para, this is the admission of the other 3 landowners.
Respondents.
This position is also admitted by respondent 5 to 7, where the petitioner's father also included. In the affidavit of opposition, when it was stated in para 6 of the affidavit that equal appointment have been given to all the 4 landowners of the by the department. This was the specific statement made before this honorable court. So these facts they cannot twist in the present writ petition. They cannot take
Respondent number 7
was petitioner's father
is the petitioner's father.
in the earlier writ petition. They cannot take another stand in the earlier, in another proceedings. Then they can make a turn and take a different stand in the present writ petition. That is my condition. So the present writ petition is not maintainable, Your Lordship. They cannot come before this honorable court with a twisted facts. Lordship, Your Lordship, in compliance to the order passed in this WPC 164, the landowners, they have signed an agreement, which my learned state council is already.
Yes.
So, Your Lordship, with regard to the maintainability of the present writ petition, Your Lordship, I am allowed to refer just to one judgment passed by the Honorable Supreme Court. I am relying on two paragraphs, two short paragraphs. 2007, volume 8, SCC. Page 449. Prestige Light Limited versus State
2000.
2007, volume 8, SCC. 449. So the relevant paragraph 33 and 35.
33 and
35.
33.
Paragraph 33.
Yes.
It is thus clear that though the appellant company had approached the High Court under Article 226 of the Constitution, it had not candidly stated all the facts to the court. The High Court, in exercising discretionary and extraordinary jurisdiction under Article 226 of the Constitution, over and above, a court of law is also a court of equity. It is therefore of utmost necessity that when a party approaches a high court, he must place all the facts before the court without any reservation. If there is suppression of material facts on the part of the appellant or twisted facts have been placed before the court, the writ court may refuse to entertain the petition and dismiss it without entering into merit of the matter. And should become the paragraph 35. It is thus well settled that a prerogative remedy is not a matter of course in exercising extraordinary power. Therefore, a writ court will not indeed bear in mind the conduct of the party who is invoking such jurisdiction. If the applicant does not disclose false facts or suppress relevant facts or is otherwise guilty of misleading the court may dismiss the action without adjudicating the matter. The rule has been involved in larger public entries to deter unscrupulous litigant from abusing the process of court by deceiving it. The very basis of the writ jurisdiction rests in disclosure of true, complete, and correct facts. If the material facts are not candidly stated or are suppressed or are distorted, the very functioning of the writ courts would become impossible. As per the records, Mr. Fosili from their plan has already availed the appointment. But what the present writ petition has stated in paragraph 18.9. This is not as per the record. So the present writ petition is not maintained at all. That's all.
Yes, Mr. Zhao.
Yeah, my lord.
You do not deny that respondent number 7 in that earlier WPC is your father, isn't it?
Yeah,
Mm.
my lord. I would like to mention here
Mm.
that in the agreement,
Mm.
it is specifically written as for landowners.
Yes.
Yes, for
No,
landowners.
that is not denied.
Now here, in the annex, in the this thing affidavit in opposition, I mean, in the additional affidavit.
Mm.
Now here, the four landowners, Mr. Rivers Jadi, who is in serial number 4, has been appointed. Now, Mr. Charu Rulho also has been appointed.
Mm.
Then Mr. Chorhelia also has been appointed.
Mm.
Now, Dole has never been appointed, nor his son. Now here in the agreement, if we go in the agreement is signed by Dole. But the signature here do not show that he is literate. He is illiterate. Now here, my lord, I would like to come to and it's just C1.
C1 of your
C1 of
petition.
my plate, yes.
Mm.
Yes. C1, Nivotsoli is the son of Zohele. Nivotsole has made a declaration that Dole's son nor his family members were appointed. The agreement, the original agreement says land owners. That's very specific.
No, it was 4 clans, no, 4 clans had donated. 4 clans represented by these 4 people.
My lord, not clan. In the original agreement, it is saying, it is stated that there are 4 land owners. 4 land owners. Their name are very specific. Had it been written clan, I have no claim. But in the agreement, it's not written clan. In the agreement, it's written land owner.
But in WBC 164 of 2001,
My lord.
the admission is already there that everyone has been accommodated. And your father has admitted also.
Yes. But here,
Para 6.
I'll come to that.
Mm.
My lord, in agreement, page 9, affidavit in opposition. Page 9.
Mm.
This document has been executed by 3 persons. One is Dolie, one is Dosiele, and one is Nivosole. And here it is stated Nivosoles has not availed, but in the additional affidavit, Zorele has already availed, and Nivosole has made in his affidavit in my plane. Nivosole has again made an affidavit in my plane. In page 21. Then coming to page 26 of the plane. Page 26 of the plane. Order has been passed to the effect on basis of the land owner, not clan. Had it been clan, I have no case. But he is very clear, land owners. That's all.
heard learned counsels for the parties.
Your Lordship, just one clarification, whether the 2018, which the petition is relied upon, can we say that whether in that declaration,
Which
the
one? Which one?
person, 2018, he has actually relied on one 2018
That affidavit-
declaration, Your
that
Lordship.
affidavit,
Now, whether that is that has been executed after the policy has come out, Your Lordship, one thing, Your Lordship. Policy has come out that it cannot be, there should be no agreement giving land ownership by way of, in lieu, giving appointment in lieu of the land given, Your Lordship. The agreement is already there. This declaration was done in 5th September.
affidavit is
2018.
dated, yes.
Policy has already come out in
2018.
Your Lordship. Now, not whether this declaration will be admissible and whether this person has ever right that he has authority that no, the petitioner is entitled to be appointed. I mean, whether he has the authority also, that can also be considered while passing the judgment or not, Your Lordship. Because this declaration is after the policy has come out. And secondly, whether this person has the authority, whether he's a competent authority to say that appointment should be given to the petitioner. Your Lordship, that's it.
Against the policy.
Yes, Your Lordship. If so, I agree with the petition for the open tenancy.
Heard learned counsel, Mr. Emil Zal for the petitioner, Ms. M.S. Levika, government advocate, and Sri Limawapang for the respondent number 5. This petition is disposed. I will pass order in the chamber. Chamber disposal.
For hearing, item number 17 and 18.
Please, Your Lordship. My lord, my senior is still attending to another case in court 1.
Let's pass it over for today.
Lordship, if I just make one request, Lordship, the prayer for interim, Lordship, that has not been heard yet, the FAO. And the stay has already been granted. And my property is subject to damage. It is still subject to damage. The order was passed on the 16th, I believe on the 16th of January by this honorable court
This year,
this year, Lordship. So,
but
If-
we cannot hear.
yes, yes,
without the
Lordship,
other
yes, Lordship.
party.
I understand, Lordship.
Mm.
So that was just my concern, Lordship,
Yeah,
because
understand. So that's why I'm saying, can we hear it tomorrow?
Lordship, tomorrow, actually coming out from Dimapur, so
Mhm.
the order was
Then-
passed on
then
16th.
Monday,
Lordship, if we can fix it on Tuesday, Lordship.
Tuesday,
Yes, Lordship.
okay, that'll be 18th. Okay.
Yes, Lordship.
You're for the appellant, no?
Lordship, no, I am for the
You're for
respondent.
the
Lordship.
respondent.
Yes, Lordship.
Okay. Learned counsel, your senior,
Joshua Shiki.
okay, learned counsel, Joshua Sheki appearing for the appellant is stated to be on legs before the division bench. Accordingly, the prayer is made to adjourn the matter. Stop. On the other hand, learned counsel,
Nikato, what's up?
Nikato Wotsa, appearing for the respondent. How many respondents? All the respondents?
1, 2, 3.
Appearing for the respondents 1, 2, 3, has submitted that there is an urgency in disposing of the IA. There is
Yes.
an IA,
Yes, Lordship.
the IA regarding interim order. Since this court by order dated
16/1/2025.
16/1/2025. No, it's 16/1/2025, there's no interim order.
Lordship, there was the interim order passed earlier in Civil Revision 1324, shall continue till the next returnable date, Lordship.
Lordship, the first interim was passed on 30/7/2024. And however, in we were
Oh.
asked to change from civil revision to first appeal from orders.
Okay. So that's why that.
Yes,
order
Lordship,
is not
it was
yet-
converted to AFO.
Okay.
from civil revision. Hence, the order was passed earlier this year as well.
But in this FAO,
Yes, Lordship.
16/1/25,
2025.
nothing is there. It just
16
says as prayed for by the parties listed as matter on 3/2.
If you want-
16/1/25.
Yes, Lord, I will just.
This is
download it
16/1/25.
from the Website also.
Uh,
think you have the
Lordship,
others.
I have that.
Okay.
You have the
Yes,
others, no?
yes.
It is 16 correct? 16 no?
Pause in IA.
Okay, okay. Yeah, last line. What did I say? No. Okay. Since by this, by order dated 16/1/25 in IA Civil 223 of 2024 had extended the interim order passed earlier in Civil Revision 13 of 2024 till the next date. And he therefore submits that there is an urgency in hearing the interim prayer. So accordingly, list the matter on 18th March 2025.
Lordship, the interim may be continued.
The interim will continue till the next date.
Obliged by your-
Lordship.
This is part of this, no?
But my property, no, not that. Subject to have also.